means you're out of time. We ask that you please respect those time constraints. One very important thing, these arguments are being live streamed. What that means for everyone arguing is please think about what you're saying before you say it, because once you've said it, it's going out there and there's no way to pull it back. So just think about that. Your panel for this afternoon, and I just now realized I forgot to introduce the panel this morning. That's great. Is Judge Arnold Golden from Memphis, Judge Carmen McGee from Savannah. I'm Steve Stafford from Dyersburg. I want to share with you one thing before we begin, and that is this afternoon is the last scheduled oral argument for Judge Golden. For those of you who do not know, Judge Golden has announced his intention to retire and will, I think, retire in January 3 of next year. I've had the privilege of serving with him for the past 10 years. And Judge McGee has served with him for what, 8? Is that right? 5? It's a number. Anyway, we've been very privileged to serve with Judge Golden and sharing his wisdom and insight, and we'll miss him. Judge Golden.
Well, I just want to say it's been an honor to serve with you, Judge Stafford, Judge McGee, and certainly Judge Armstrong, as well as my colleagues on the middle section and the eastern section of this court. It's a very bittersweet moment for me. I want to thank my assistant, Natasha Langston, who's sitting in the back. She's been with me for 22 years since I started in Chancery. And I'm certainly looking forward to what happens next, but I will certainly miss being with everyone. Miss Angie in the clerk's office here, thank you so much for all you've done. And I think it's, as I say, a bittersweet moment, but I'm looking forward to the next step. So thank you all.
I think I incorrectly said that he's going to be retiring. He's not going to be retiring. He's just not going to be serving on the court actively. So we'll leave it at that. We will very much miss Judge Golden. Miss Angie, anything we need to take up before we get started?
No, Your Honor.
You may call the next case then.
Janice L. Ruiz versus Butts Foods LP et al.
And we will hear from the appellant.
Good afternoon, Your Honors, and may it please the court. My name is Wesley C. Redmond, and it's my privilege to be here today, particularly on Judge Golden's last day of argument. On behalf of Butts Foods LLP and Kirch Foods LLC, I would like to reserve 3 minutes for rebuttal.
All right, sir.
The issue we are here today asking the court to reverse the decision of the Chancery Court of Madison County in which it refused to uphold an arbitration agreement. The issue today is about a plaintiff who signed a valid arbitration agreement in which she agreed to arbitrate her claims against the company. We think the court needs to consider this case through the lens of 2 well-established concepts. Number 1, the policy favoring arbitration, and 2, the idea recognized by the United States Supreme Court that arbitrable and non-arbitrable claims can appear in the same case, and with the former being sent to arbitration even if the result is piecemeal litigation. The arbitration agreement that we're here today was signed by the plaintiff, who was an employee of the defendants, and it is enforceable, with the only issue being if enforcing it violates the Ending Forced Arbitration of Sexual Harassment Act, which prevents arbitration of certain claims. The Chancery Court below made 2 alternative rulings, one of which I think we can dispose of quickly. One of the rulings the Chancery Court made was that because the lawsuit was filed after the enactment of the act, and the primary issue of the language that we're here on today is the provision in the Ending Forced Arbitration Act that says that it only applies to any dispute or claim that arises or accrues after the date of the enactment, which would have been March 3rd, 2001. The Chancery Court ruled that because the lawsuit was filed after that date, that the act applied to it. But this court's own decision in Grimsley ruled otherwise. There was a case out of Williamson County, I believe, that had ruled similarly, and the Grimsley court has overruled that. The other ruling was that the Ending Forced Arbitration Act applied because the dispute was one that involved a sexual harassment claim. The subject matter of the plaintiff's complaint is relevant because she alleges one count of sexual harassment against the company along with 6 state tort claims. And the one count of harassment against the company is the reason we're here today. We want to begin by pointing out we want the same thing as the plaintiff does. We want this matter to be heard before a neutral decision maker. We are not trying to delay things. We just want this case to be decided by the correct forum. And we understand the importance of this case and this kind of cases. The issue, which is novel in this state, is regarding a sexual harassment claim in which some of the alleged conduct to support occurred before the act was enacted and some after. But what we have in this case that few other cases have, particularly few of the other cases cited by the plaintiff appellee, and it's been watered down a little bit in the briefs, and it's been watered down, I think, in the Chancery Court's opinion. It has been said that the conduct began before the act. Her allegations in the complaint was she began work in January, and within a few weeks, things began to happen. Plaintiff has argued, well, what she says is that conduct began after a few weeks, and I believe the Chancery Court said that, and it might have even creeped into our brief some. But what actually was said was, within a few weeks, plaintiff was subjected to a sexually hostile work environment and was subjected to sexual harassment. That was said in the original complaint. It was said in the amended complaint. It was said in the affidavit. In other words, the allegations in the complaint and in the affidavit the plaintiff filed, which is all we have in front of us to make this decision, indicated that she was not that the conduct began, not that comments began, but that there was a fully accrued cause of action for a sexually hostile work environment and sexual harassment that began in January or February before the act was enacted. They had a fully accrued judicial remedy at that point, according to the allegations. We, of course, deny that as the merits, but we're not here to decide the merits today, just as to whether, based on the allegations, this matter should be subject to the Federal Arbitration Act, or is it prevented by the Ending Forced Arbitration Act. And this is the reason why we sought arbitration in this case, because she stated clearly that she was subject to a sexually hostile work environment within a few weeks after she was fired. Yes, there are other events they talk about that occurred after, but those are not new claims. Those are just additional evidence to support her original claim that she made.
Why is that not a new claim every day?
Well, no court has ever recognized that it's a new claim every day. They have talked in terms of, and I'm sure if the briefs in the case talk about the idea of what's known as a continuing violation, which we say doesn't apply here because this is not a statute of limitations. This is not an issue of where you have to look at months long of acts that have occurred. She's alleging very clearly that I had a cause of action before this statute went into effect that would have prevented our arbitration of this type of claims. And it's that allegation that we are relying on.
Well, I'm not sure you answered my question.
Yes. But
Why can it not be a new event every day?
there is no case I know of that has ever held that it is a new cause of action, that it's a new claim that exists. And in this case, all she has alleged is one count with one claim for sexual harassment and she talks about a number of different events that occurred. But she was very clear in her complaint that she had a fully formed cause of action before the action was filed. We don't think that it...
Why can't the new events form a new cause of action each day?
If the plaintiff wanted to plead it that way, I think the plaintiff could. But that's not how they pled it here. And so if it's a new event, you would run into the situation, which we think may very well apply here, where you would have some claims that are arbitrable and some that are not. If the events that occurred, as she alleges, created a hostile work environment before the act was filed, but they said it is a new claim, it's a new cause of action, that is a completely separate one, that we may not be able to prevent that. That's not the allegation here, but if that was to be how the court was to construe it, we would say, well, then you have some arbitrable claims and you have some non-arbitrable claims. The other issue that I think has been watered down a little bit is the issue, there's an allegation about when the conduct became severe and pervasive. And the Chancery Court, I believe, indicated that because she claims it became severe and pervasive in April of 2023, that's after the act. Number one, that's contrary to what she already said, that she had a full judicial remedy and a cause of action before, but that's not actually what the allegations are. The allegations were that it became so severe and pervasive that she finally decided to report it. Not that it was severe and pervasive as a matter of law, but that it got severe and pervasive to her individually that she decided to report it. Under sexual harassment law, whether it's severe and pervasive is an objective standard. The plaintiff doesn't get to define that. So to say that because of that allegations, that's when the cause of action accrued, that's not actually what the allegations were. She just said that's at the point where she decided to report it. So our position is that because she had a full cause of action that accrued before the Ending Force Arbitration Act went into effect, that this claim should not be subject to that. Based on her complaint, a full judicial remedy was available to her. And as a strategy, plaintiff chose to allege the hostile work environment existed before March 3rd. But she may have overplayed her hand by pleading herself out of the Ending Force Arbitration Act. To answer some more about what the court was addressing earlier, the alleged conduct that occurred after March 3, we say is not subject to the Ending Force Arbitration Act because she has one claim. She has one claim that has already matured. And the Tennessee courts have found that a dispute arises when there is a judicial remedy that is available. And again, according to her own allegations, her judicial remedy was available before March 3. And so any additional alleged conduct that occurred is not an additional sexual harassment claim. They have not pled it that way. They have not tried to argue that. Again, notably, per her complaint, she admits the sexual harassment occurred before the act went into effect. But
I know there was a motion to dismiss. Were these arguments made to the trial court as well?
yes, sir.
Okay.
Yes, they were.
It was suggested to the trial court that these differentiations needed to be made.
The briefs, yes, the briefs would have pointed out exactly what was said, which was that she alleged that she had a cause of action that existed as of March 3, 2003. Yes, that was argued to the trial court.
And that these distinctions in dates and causes of action, that they accrued at a different time, and the trial court needed to make these determinations.
I don't think it was argued exactly that way. That issue was not raised as to whether or not these could be brand new causes of action, and the court needed to decide when additional cause of actions might have accrued. I think at the Chancery Court, we were looking at it as one single claim, and when did that one single claim accrue? That's what the Chancery Court was deciding, which was in front of it. And
my concern is that oftentimes we make distinctions in the appellate court and send matters back to the trial court to make decisions that the trial court was never asked to make in the first place.
But we certainly asked the trial court to make the distinction that, or to make the decision that her cause of action for sexual harassment accrued and existed before the act went into effect.
I understand that. I can tell that from the order. I'm just talking about the additional things that we're discussing here as well.
Again, we did not discuss the issue about whether or not there could be new causes of action, that each supposed event or series of events creates a new cause of action. I do not believe that was discussed at the trial court. And I see my time is up.
Thank you.
Good afternoon, Your Honors. My name is Jason Lee. I represent Janice Ruiz in this sexual harassment case against Butts Foods, Quirch Foods, and James Goodrich. This case is a sexual harassment case involving grotesque sexual harassment. The case was filed in September of 2022. The amended complaint was filed in November of 2022. That's the operative complaint. We also filed a declaration of my client that outlines the facts that are important to the issues in this situation. Those are uncontested. My client was hired on January 18th, 2022. Within a few weeks after she started working, she began to be subjected to sexually harassing conduct from her manager, James Goodrich, comments and actions. This conduct worsened over time. The record on page 192 shows that the majority of the sexual harassing comments, actions, touching, everything occurred after March 3rd, 2022. Further, the records show that the sexual comments and sexual actions directed at my client became at the point of being severe in April 2022. My client's own declaration states that it reached the point of being severe in April 2022. At that point, she reported it. Not only that, the conduct continued after that, continued all the way through August of 2022, when my client reported the Human Resources Department. At that time, the Human Resources Department made excuses about the male employee. This conduct is continuing. After the August 2022 report, my client was retaliated against. She was retaliated against for months, which ultimately led to her constructive discharge in February of 2023. That was the end of her employment. I do want to point out that there's been no motion or filings by the individual defendant, James Goodrich. He does have counsel, so this case is proceeding to court regardless. The Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act clearly decides the issues before this court. The statute was signed into law on March 3rd, 2022, just a month and a half or so after my client began her employment. The term sexual assault dispute is defined as meaning a dispute involving a non-consensual sexual act or sexual contact. Sexual harassment dispute means a dispute relating to conduct that is alleged to constitute sexual harassment under state law. These are very broad definitions. The purpose is clear, and what's important here is the public policy in America is no longer that arbitration is favored. Counsel referenced that and talked about that in their brief. The policy now is in sexual harassment and sexual assault cases, it's illegal. This was a 100-0 vote in the United States Senate. This was a unanimous determination. So the new public policy after the enactment of this act is that arbitration is illegal at the election of the plaintiff for a sexual harassment or sexual assault case. So then the question is, when does the cause of action accrue? For a sexual harassment case to exist, the conduct must be severe or pervasive, objectively and subjectively.
Who makes that decision?
In this situation, it's based on the evidence before the court, which is the amended complaint and the declaration, which are both consistent. That's all that there is. There's no countervailing evidence. It's only once the conduct reaches the level of severity that is actionable under Title VII and THRA, which uses Title VII. For my client, it reached that level in April 22 at the earliest. Counsel referenced this, the severe and pervasive. If you look at paragraph 11 of the amended complaint, my client specifically pleads that it became severe and or pervasive in April of 2022. The case law is clear that there is a requirement of severity. The first time someone makes a sexual comment does not equal an actionable claim under the THRA or Title VII. The totality of the conduct must be severe or pervasive. That often takes time for it to develop. Further, the vast majority of actions directed at my client occurred after March 3rd, 2022, the effective date of this statute. All of the sexual harassment retaliation was after March 3rd, 2022. My client's constructive discharge was in February of 2023, well after this statute. The defendant seems to argue that the claim could have arisen or accrued before it actually legally existed as a cognizable claim. That would lead to an absurd result in this situation. The defendant also cites the cases talking about how this statute should not be applied retroactively. That's clear. I was the Grimsley attorney. I lost that before the Court of Appeals. In that case, she was terminated months before this act was passed. So there's no doubt that has been universally applied across the country. But all the cases that have dealt with this, and you'll notice in their brief, all the cases find that in this situation, when there's conduct before and after, that the act applies. And the cases universally, and this includes the Johnson case, Olivieri, Watson, Dello, Betancourt, they're coming out every week, just about. It's constant. These cases applied the continuing violation doctrine. In a hostile work environment claim, each event occurs and reaccrues the conduct. These courts found that because the conduct continued after the enactment of the statute, then the statute applies to bar the arbitration agreements. That's what the trial court found in this case. Now, just a couple weeks ago, we have our first United States Court of Appeals decision from the Second Circuit. That was actually the Olivieri case, which I cited as a district court opinion. The Second Circuit dealt with it. They ruled the same way. The court said, to get there, we consider what it means for a claim to accrue and conclude that the concept is tightly bound with the operation of statute of limitations, which is consistent with Tennessee cases. Thus, when a claim accrues, turns on the law applicable to the type of claim in question. In the context of claims subject to a continuing violation doctrine, a claim first accrues when the plaintiff has an actionable claim. But because such a claim is a single and indivisible claim arising from numerous specific acts undertaken in a continuing course, the claim reaccrues and is essentially reborn with each successive act that is part of the continuing course. The court then stated President Biden signed the EFAA on March 3rd, 2022, while Olivieri was wrapping up maternity leave. By the time she returned to work a week later, the EFAA was in effect. So if Ms. Olivieri has alleged that upon her return, defendants engaged in acts that are part of the same course of conduct underlying her hostile work environment claims, those claims have accrued after the EFAA's effective date. So she has so alleged, and the court found that. The court, it's a very good case. It talks about the textual analysis and breaking down everything, and I'd encourage the court to look at the detailed analysis. But it's consistent with all the other cases. We cited numerous cases. The cases cited by counsel or by the defendant do not hold that. Now, the second issue, which is addressed in the brief at length, but wasn't addressed in oral argument, is the claim that because some claims are Tennessee tort claims beyond the THRA claim, that those should be carved out and somehow some kind of a hybrid case arbitration. There is no case law to support this. In fact, the plain language of the statute makes it clear. The key language in the statute definition for a sexual harassment dispute is that the statute applies to a dispute relating to conduct that is alleged. It doesn't say that's a statutory sexual harassment claim, relating to the conduct. The term relating to the conduct is extremely broad. Congress could have limited it to just statutory claims under Title VII or THRA, but they did not. The definition for sexual assault dispute is even broader. It says that it covers disputes, quote, involving a non-consensual sexual act or sexual contact. It doesn't limit it to just the statutory claim. It is much broader than that. Now, maybe even more importantly, which most of the cases talk about, is that the statute says when there is an election to proceed with a lawsuit, the arbitration agreement is not valid or enforceable with respect to a case. 9 U.S.C. 402 specifically says, notwithstanding any other provision of this title, at the election of the person alleging conduct constituting a sexual harassment dispute or sexual assault dispute, which is my client here, No pre-dispute arbitration agreement or pre-dispute joint action waiver shall be valid or enforceable with respect to a case which is filed under federal, tribal, or state law and relates to the sexual harassment dispute or a sexual assault dispute or sexual harassment dispute. It clearly says the entire case is not subject to arbitration. The word is case, not claim. That would be a different argument. The broad language of this statute make it clear that all claims that are brought in this case are not subject to arbitration. Tennessee courts look at the gravamen of claims, as this court is well aware. The gravamen of this case is a sexual harassment dispute, a sexual assault dispute. Further, it would lead to an absolute absurd result to allow to somehow carve out certain claims for arbitration and some for court. That would be incredibly inefficient. Almost all claims, this is all I do, I only file sexual harassment claims at this point in my career. They always have tort claims. What this means under defendant's theory is that their interpretation would completely decimate the purpose of this statute and allow defendants to avoid the statute if there were any claims brought beyond just the statutory claim. Automatically, it's not subject to arbitration. That would decimate the statute. Now, what did we cite to? We cited to numerous cases that decided this exact issue. Johnson, Watson, Turner, Dello, Avalez, Malkinoff, there's more cases coming out consistently, that they all have built on this determination and found that when there's tort cases or any other type of claim with the sexual harassment or sexual assault claim, then all of them are not subject to arbitration in that context. Just a few weeks ago, a Scroggins versus Menard case, an Ohio District Court case, came out consistent with our position. There's many, many cases on this issue, and it's been universal. Now, defendants cited a case in their reply brief called Osario versus CVS, but that's not even a sexual harassment claim. I don't know why it was cited, but it's cited for a proposition that is not accurate. They also cited Dixon versus Dollar Tree case. The Dixon versus Dollar Tree case they used to argue in their brief, and they actually complained that the trial court did not address Dixon versus Dollar Tree. The reason is this: the actions in Dixon versus Dollar Tree occurred from 2017 to 2020, 2 years before this statute. The court simply said, we're not applying the statute retroactively. That's been determined across the board. That case has absolutely nothing to do with the facts that we have here today. The facts that we have here today is a bridge. It's a case where there's some conduct before, very minimal, conduct after, and there's two reasons why that comes within the statute. First, the cause of action didn't accrue under any definition until afterwards. Second of all, the continuing violation, which the trial court provided as an alternative finding, dictates that each time that conduct occurred, and we're talking about it occurred almost a year after this, continually, that is a new event and it's a new accrual. So it clearly comes within the statute. The bottom line is that the defendant simply doesn't have any position in the case law for their case, for their argument. The language of the statute and the language in the cases interpreting the statute have been nearly completely unanimous across the country, including now Court of Appeals opinions. They have rejected the position of the defendant, and we request the same. Unless this court has any questions, that concludes my argument.
I see none. Thank you.
Thank you.
Your Honors, there's a few things I would like to make clear. Number one is, of course, we deny the merits of what the allegations are in the complaint. Appellee spent a bit of time talking about the merits and what happened, and we deny those. We also deny that there's any allegation in the complaint of any sexual assault. It is simply a harassment claim. And I want to be clear to the court that our motion, our request for arbitration is based on the admission that existed in the complaint, the amended complaint, and in the declaration that before March 3, 2003, she was subjected to a sexually hostile work environment. You heard again today from this podium where I told you that the language, that those admissions had been watered down. I heard plaintiffs say she began to be subjected to. And I think that's what Plaintiff would like this court and wanted the trial court to believe, but that's not the allegations. The allegations are that a full remedy existed before March 3. And I'm not claiming, defendants are not claiming that a cause of action accrued before it existed. We're saying, based on their own admissions and their own documents, the plaintiff is saying that she had a cause of action. And not all cases say that before and after events results in a continuing violation. We will admit there is a lot of case law that supports the plaintiff. And if we were arguing this case in New York or California, I would say we would have very little chance of being successful. But when you look at Tennessee law about when a cause of action accrues, and you consider what we have in this case that does not exist in any of those cases, is the admission that a full cause of action existed before the act was put into place, before it was enacted. The conduct creating a sexual harassment, that's the definition. And one thing that makes the act a little hard to read is it talks about a case relating to a sexual harassment dispute, but then talks about conduct relating to an act of sexual harassment. The definition of a sexual harassment dispute is conduct creating a sexual harassment. Congress could have said any case that mentions sexual harassment goes to arbitration, but to follow what the plaintiff is asking and to follow what some of the courts have said has led to some unusual results in which race discrimination, religious discrimination, pay claims are being denied arbitration, although the plaintiff agreed to them, because there happened to be a harassment claim that is in there. He talked about the word case, but the case have to have accrued after March 3rd. And it has to be a case, it says a case that relates to a sexual harassment dispute. And I see my time is up. Thank you, Honor.
Thank you. Thank you, counsel. We will review this matter and attempt to get you an opinion at the earliest possible time. You may be excused.
Thank you.